Hello, my name is Joy Poe. I am covering intellectual property, trademarks, and copyrights for ENT 630 Entrepreneurial Growth. We're going to begin with the idea of your brand and how to protect your brand through trademarks and copyrights. Starting with Susan Gunilius's article, What is a Brand? She has 5 points that come together to define the brand. The first is the brand promise, which is a combination of the quality of the product and the feeling the product brings the consumer when they purchase and use the product. The brand perception, in a nutshell, is the way the consumers perceive the brand, despite the company's presentation of the product. The third is brand expectations. This is referring to consumers' assumption that the money they spend on your product lives up to the quality and other expectations they have of your brand. The brand persona is the appearance and personality and everything in between your brand has that consumers will evaluate and judge before they do business with you. And finally, the brand elements, the above elements combined with your logo, messaging, packaging, and other elements of branding a product, working together to fully promote your product in the best way for optimal growth. Moving on to the actual definition of trademarks and copyrights. They are often confused along with patents, but they all three protect different kinds of intellectual property. The U.S. Patent and Trademark Office defines the terms as such. A trademark is generally a word, phrase, symbol, or design, or a combination thereof that identifies and distinguishes the source of the goods of one party from those of others. A service mark is the same as a trademark, except that it identifies and distinguishes the source of a service rather than goods. A copyright protects the original works of authorship, including literary, dramatic, musical, and artistic works such as poetry, novels, movies, songs, computer software, and architecture. Some things cannot be copyrighted, such as names, domain names, titles, slogans, logos, ideas, sightings, Elvis, aliens, facts. This is a note on a piano. You can't copyright the key of A, systems, methods of operation, and simple ingredients for recipes. And then finally, we want to talk about patents simply because they're kind of often confused with trademarks and copyrights. A patent is a limited duration property right relating to an invention granted by the United States Patent and Trademark Office in exchange for public disclosure of the invention. Patentable materials include machines, manufactured articles, industrial processes, and chemical compositions. Copyright facts. A copyright protects original works, both published and unpublished. A Copyright Act of 1976 allows the owner the rights to disseminate the work in any manner way they choose, and it's illegal for anyone to violate their rights. If an owner's rights are infringed, a court will provide the remedy to the issue. Copyrights are secured when the work is created and fixed as a copy, so work does not need to be copyrighted to claim copyright. Your work must be legally registered with the Copyright Office in order to be able to file a copyright infringement claim, however. Applications are in the public record, so be cautious if you have a secret recipe or other things that you wouldn't want the public to see. Copyrights are highly recommended by the United States Patent and Trademark Office for a variety of legal reasons. Duration of copyright depends on a variety of details outlined in the application. And copyright protection through the USPTO does not protect your work outside of the United States. Public domain and Creative Commons. Often we find materials outside of copyright regulations. These materials fall under public domain or Creative Commons. These notations allow usage for materials without the need for copyright permission from the artists. Materials fall under public domain in 4 ways. The copyright has either expired, the owner did not renew it, or the owner dedicates it to the public domain, and finally, there's the possibility that copyright law just simply does not protect that kind of work. The Creative Commons allows creators to free their work of copyright laws internationally and ensure the work is free everywhere. You must be the author of the materials to donate it to the Creative Commons. The images to the left are available under the public domain or PDM. All of the other images in this presentation are available under the Creative Commons or CC0. Neither designation requires citation, although a reference to the source of the material is always appreciated. Remember, a work is copyrighted when it's created and copied, but you cannot sue for copyright infringement unless the work is registered as copyrighted. The copyright symbol is proof that your work is legally registered. And then I also added a few things: poems, short stories, novels, copyrighted when written; visual art, copyrighted when first created; photographs, the same, copyrighted when they're first created. Trademark facts. A trademark is not an umbrella that covers domain names or business names. Domain names are registered with a domain name registrar. A business name is not necessarily a trademark, but it sometimes can be. Some states, including North Carolina, require business owners to register their business name with the state or local jurisdiction. This is called doing business as, or registering for a DBA. A trademark is registered through the United States Patent and Trademark Office. Selecting a unique mark is the first step in registering your trademark. Not every mark is legally protectable, and not every mark is registrable with the USPTO, which means you must consider if your mark is unique enough to be registrable and if your mark is strong enough to be legally protected. You, as the trademark owner, are solely responsible for the enforcement of your mark. The USPTO states the most common reason for a trademark application to be rejected is the likelihood of confusion between the mark of the applicant and a mark that's already been registered. It is the responsibility of the applicant to perform a trademark search to ensure the mark will not have a likelihood of confusion. The likelihood of confusion is made up of two parts. Your mark must not be similar to any other registered mark that looks, sounds, or means something similar. Neither can your mark have a similar design element or a similar general meaning. And then in addition, your mark must not have a related goods or service similar to another trademark. If your mark only has one conflict, your application could still be accepted, but if your mark has both conflicts, your application is likely to be rejected. In addition to selecting a mark that's not easily confused with other trademarks, your mark must also have a trademark strength. This is yet another rather ambiguous requirement. A strong and unique mark will prevent future applicants from having conflicts with your registered trademark. A complete trademark search can identify any problems with your mark and prevent you from a rejection from the USPTO. The government site offers the Trademark Electronic Search System online and offers a wide variety of help topics in conducting your search. The search process, however, is extremely complex, and the USPTO highly recommends hiring a trademark attorney to assist in your search. The USPTO's database of trademarks does not include marks of parties who have common law rights to their mark. Common law rights may be stronger than your application's mark due to the length of business of those common law right owners. So common law rights, a common law trademark is an unregistered trademark that starts when a business begins using a mark in commerce for the first time within a geographical area. It endures with continual deliberate use and is shown by the superscript TM. A business is not required to register a trademark, so a common law trademark can stop a competing business from using similar marks that can confuse consumers in your area. Common law trademark rights are limited to the geographic area the intellectual property is used in, and any areas where it could reasonably expand. Trademark attorneys, according to Wikipedia. In the U.S., trademark attorneys are attorneys at law who specialize in trademark matters. Trademark attorneys may be in a subdivision of a larger firm that deals in intellectual property, or may have a discrete firm dedicated entirely to trademarks. If a corporation frequently has need for a trademark attorney, the business will employ a full-time trademark attorney. The benefits of trademark attorneys would be that while the USPTO will help an applicant move through the application process, once you hire a lawyer, the office will only speak with your attorney about your application. It rather helps you wash your hands of having that complicated process. Hiring a trademark attorney will ensure a thorough trademark search, a more favorable application, and aiding in the enforcing of your trademark once it's secured. You can see how hiring an attorney, while not required, may save you from costly future legal problems, including the issue of common law trademarks and trademark infringements. The USPTO cannot provide you with legal advice, therefore you may consult an attorney referral service, the internet, or state or local bar association in order to find a trademark attorney. Application costs and the time frames. For copyrights, the basic registration begins at $35. Filing online is less expensive. There are a variety of additional fees based on the kind of registration you need. Some applications require Copyright Office to conduct searches, which will cost more. The Copyright Office also charges a fee to record your document to the public record. You can peruse some copyright fees here. It's at copyright.gov. If all materials and fees are submitted correctly, a copyright application will take 6 to 10 months to be processed. For trademarks, there are many factors that affect the filing fee for a trademark application. Generally, there are 3 options with specific requirements. The options range from $225 to $400. You may peruse the trademark fees and requirements, again at uspto.gov. If all materials and fees are submitted correctly, the USPTO will send a filing receipt almost instantly if you're filing online and will contact you within 3 months. The trademark registration, however, may take up to a whole year to receive. And here we have resources for copyrights and trademarks. To begin your search for accurate information at the United States Patent and Trademark Office. For information regarding how to enforce your copyright, you may go to copyright.gov. For information on how to proceed with trademark infringements, you can go to stopfakes.gov. nolo.com is a legal encyclopedia. You can go to trademark searches at tmsearch, uspto.gov. You may look up trademark attorneys at various places. USPTO has some. You can probably also go to the NOLA site. For more information about public domain and Creative Commons, you have creativecommons.org and publicdomainarchive.com. You may also check out the fairuse.stanford.edu. And for information about using copyrighted music, you can go to ascap.com. Thanks so much for listening. I hope this was informative for you, and good luck if you ever had the need of copyrights and trademarks, and prepare well ahead of time. It's going to take a while. Thank you.